All right. Hopefully this is running. There's going to be a little bit of hiccups here at the start while I just make sure that everything's going. Are we getting good audio and video here? And I think there's about a 30-second delay, so I'll just start talking here. So today I wanted to talk a little bit more about the Alec Baldwin case. Let me know again if there's any sort of audio-visual hiccups here. But essentially, this is one that's been really frustrating to see in the media because there's lots of people who have comments, and a lot of the comments are just basically that you've got people who either have a grudge against Mr. Baldwin, and that's assessing their assessment of things, or people who have a grudge against firearms, and that's influencing their assessment of things. And that's not really my style or my speed here. I really want to approach this from a perspective of, what is actually the law or what is actually reasonable here. So, as I said before, this is a situation where it's really hard to understand how things happened the way they did. There's so many things that seem to have gone wrong. And I spoke to a lot of people in the industry. I spoke to, armorers who are, I think, the most essential people to get perspective from, but also people who've been involved in other roles, including one actor who uh, cannot name because they were like, do not name me, do not, this could affect my career. But just talking about the safety protocols that are normally in place and how they went wrong here. Because normally what we've got in place is all sorts of things in terms of, I'll sort of back up a little bit here. Normally at the range, and I sort of made this point earlier in my previous video, but you've got the four essential safety rules. Don't point the firearm at anything you don't want to put a hole into. Always assume the firearm is loaded. Keep your finger off the trigger, and so forth. The problem is that when we start looking at a film set, a lot of those rules end up getting broken, and that's because of the necessities of a film set. You might have it where somebody needs to point a firearm directly at the camera, and there are ways where that can be mitigated. You could, for instance, have the camera rolling and nobody behind it. But sometimes that's just not possible. Sometimes you want that to be, sometimes you need that because the camera's got to be operated in some fashion. So that's, a circumstance where you might end up breaking that rule. Or you might have two actors pointing firearms at each other. Sometimes that can be done with very clever camera angles, such that, the same way if an actor takes a swing at somebody, it might brush past their face without actually hitting them and just look like it. But, sometimes that's not possible. And I'm getting some people saying, hey, give an overview of what the situation is. So I'm not really sure how much people know about this one. Basically, what happened, Alec Baldwin shot someone on a film set. By all accounts, it's an accident, but I don't mean accident in the sense of forgiving people from responsibility. And hello to the people. Hi, Rumple. Hi, various people. I'm not going to be able to sort of address things all the time, but I will try to respond to things. But, when I say accident, I don't mean accident in the sense of nobody's at fault, because you can have like purely accidental accidents where it's just nothing, you know, nobody could do anything about it. Or you can have accidents that involve a certain degree of negligence. And that's what seems to have been taking place here. There's so many things that were going on that are just really hard to explain absent negligence. And the reports are just kind of shocking. So these reports include that the armorer wasn't the person to provide the firearm to Mr. Baldwin, that instead it was the assistant director. It's not clear why that happened, but they shouted "cold gun" as they handed it to him. And that, that's part of process, right? You want to tell the guy what it is. But there's no indication, it doesn't appear that he actually showed him that it was a cold gun. And then he was practicing draws. It's not clear whether it was a situation where he was being directed as to how to do the draw or if it was just him practicing. And that can affect things in a big way in terms of the legal implications if it were here in Canada. And I don't really know about the US rules because not an American lawyer. And the last thing this needs is somebody talking out their butt about stuff that they don't know. So I'm not going to comment on the laws of New Mexico where they were filming. But the other thing that's really concerning is that apparently this was a live round. And I mean live in the sense of able to fire a projectile. The problem that we also see is that there is muddying of terminology here. So cold gun versus hot gun. A hot gun is anything that will go bang when you pull the trigger. You know, if it's got a blank in it or if it's got a live projectile in it for, live thing that will fire a projectile for some reason. And there's very little reason why that would ever happen. I spoke to armorers who indicated that there should not be, cartridges that can fire a projectile on set in the vast majority of circumstances. There is one exception. And the exception to that is if you are actually doing something where you need the projectile for some reason because you're doing something, for instance, like a Mythbusters episode where you're shooting something, or you're doing ballistic things where it's going into ballistic gelatin. In those cases, you might need an actual projectile, but those are very rare, and that's not going to happen in a Western. If you need something where you see like a bullet impact, there's much better ways to do that. One of the things, and I'm not going to show my ID. Well, maybe I will. I'll show an ID here, but I'm going to cover up some key portions here. So this is a Pyrotechnician certificate, which is that. So I've taken the introductory intro super basic pyrotechnician course. It entitles me to do basically nothing on my own, and but I could potentially do work under the supervision of someone else. But pyrotechnicians do things that, at the higher levels involving a lot of the special effects you see. When you see somebody shooting into a door and you see the bullet splinters, they're not doing that by shooting actual live rounds at that door. They're sort of firing a blank firing gun or whatever else, and what you see are actually little explosives that they've embedded in the door in some fashion to make it look like there's bullet impacts, which is also why bullet impacts in movies tend to be far more impressive than bullet impacts in real life. I hope you've never seen video of people getting shot, but when you do, the actual splatter tends to be less impressive than when you see this in a movie. Doors being shot. Typically, an actual door getting shot is just going to be a little, a little thump there. And, you're not going to see that sort of impressive spray of wood spatter. So again, no reason for live cartridges that fire a projectile to be on set. And typically, the safety procedures include that this should never happen, that they're not available anywhere, that there is no possibility for someone to make that confusion. So that's a big deal there in terms of, safety procedures, because the other thing we've heard is that these firearms may have been used for target practice or just, plinking or goofing around off camera and, between takes. That is shocking. It is just a thing that there is no explanation for. So there's all sorts of safety issues here. But a lot of people have been real concerned about, who's going to face civil liability. And potentially, I think there's civil liability for lots of people. I suspect in the States that the civil liability is likely to be least likely to fall on Baldwin himself. I can't see a situation where the armor is not going to be in, I don't know. We don't have all the details yet. There could be something out there, but right now it looks like the armor is going to be facing some serious suits. Baldwin as a producer, I don't know what, degree of connection in terms of the financials he's got there, because there's all sorts of reasons why somebody might be listed as a producer that may not indicate that they necessarily have a whole lot of control here.
And I'm getting somebody saying, would this not all be hearsay? It would, but we're not a court of law. Hearsay is an admissibility rule. I'm just relying on what we're hearing. And the sort of note here is uh, essentially we're just assuming that these things that we've heard are true at this point, so that we can have a reasonable discussion, because otherwise we're not going to be able to actually talk about what's going on here. But in terms of Baldwin himself, the main issue here is what I've heard from, various armorers is that when they're actually handing over the firearm, what they should be doing is showing the actual actor, hey, here is the gun, here is how you know it's unloaded, here's how you know it's safe. And, either that they show them that there's nothing in it, and they might do that by, holding the action open, shining a flashlight in it. You can see there's nothing in the magazine, there's nothing in the chamber, everything is good. Or if it's a situation with blanks, showing them that each one is a blank and then putting it into the firearm. And then if it's a situation with dummy ammunition, because dummy ammunition is sometimes used, and where dummy ammunition is used on set, it's not going to have any sort of live primer, so it's not going to be able to make any sort of bang or even project the bullet itself into the barrel, because of course that is something that that was what we saw with Brandon Lee, where there was a bullet stuck in the barrel and then it was projected out later. So that's part of why, there's no primers or anything like that. It's just a dead cartridge. If you pull the trigger on it, it's going to just go click. But another thing they do with those dummies is they put ball bearings in them, so that when you shake them, it's very clearly not a firearm, or not a real cartridge, rather. Because if you shake a real cartridge, it doesn't make that noise. It doesn't go rattle, rattle, rattle. So what they should be doing is each cartridge that goes into that gun should be getting shaken, rattle, rattle, then it goes in. Rattle, rattle, then it goes in. For each cartridge, just to make sure that there is that safety element. And so the question is you've got Baldwin there, and, why isn't he insisting on that? Why isn't he saying why isn't he saying this is what needs to be done? He should, in theory, because he's been on a number of movie sets, be somebody who is experienced with this. And ultimately, I think part of the problem, there's many overlapping areas of safety, and ultimately the person responsible is the armorer. The armorer is the person who should be doing all of this. And if the armorer was cut out of the loop by the assistant director, then the assistant director is going to be facing a ton of the responsibility here. But it's a big problem here if we've got, if those people have been cut out in some fashion. But similarly, I think that the sort of practices are a bit too forgiving on actors, because right now the assumption is that the actor doesn't know anything and isn't necessarily going to behave sensibly. And perhaps that needs to change, so that the actors, if you want to be in an action movie that's got firearms in it, maybe you should have to, maybe you should have to take courses. Maybe you should have to get some training. And yeah, so it'll be really interesting to see how this shakes out. I'm going to say that this one is going to turn into civil suits. And so we're going to see a lot of stuff filed. There's going to be a lot of information that becomes public. And so we'll have to see what's going on. I'm seeing some people noting that they were noting that it's the assistant director's fault. From what we've heard, apparently the assistant director was pulled off set afterwards and told that their services were no longer required. So, yeah. I don't want to say too much about, but I do think that if this happened here in Canada, there would be a path to potential criminal liability for lots of the people involved. And it would ultimately depend on some of the facts as they came out, but it's entirely possible that some people could be facing charges, including the armorer, including the assistant director, and potentially, depending on what happened, including Mr. Baldwin. The way I would say that Mr. Baldwin would come into potential liability here It would be if he was just practicing just to get this down for himself and doing so in a fashion that is unsafe. And the reason why I say that would be a possibility here is that in Canada, you don't have the option, sort of legally speaking, to sort of absolve yourself of responsibility, even if you're an untrained shooter. Acting under the supervision of a trained shooter, you are held to the standard of somebody who should know what they're doing. So, you can't just say, listen, I didn't know what I was doing, because the court is going to say, listen, part of the standard on this is that you were required to educate yourself. You're engaging in a very hazardous activity. And I see Red Z, hopefully Red Z, I guess, bunch of small mistakes that led to the disaster got screamed about, and attention to detail in the Army back before they cared about soldiers' feelings. And that's exactly it. Every time you see any of these accidents, because there's so many safety rules, and they're designed such that you can maybe screw up one or two. If you think about on the range, the 4 basic safety rules, you can screw up any one of those safety rules and you're not going to kill somebody. But it's when you start screwing up 2 or more, that's when things get wrong. Assume the gun is loaded. Well, okay, if you assume it's unloaded, but you keep your finger off the trigger and it's pointed in a safe direction, you're not going to, cause any injury. It's the problem is that when you get complacent, when you get too comfortable with things, you you break one rule and nothing happens. And you say, okay, I've broken one rule. Maybe I could break 2 rules. And okay, nothing happened. Maybe I could break 3 rules. And you get into this habit of doing that. And eventually there's a disaster. We see this with nuclear accidents where, Chernobyl wasn't the result of just one safety mistake. It's the result of lots of corners getting cut. And eventually things go really, really wrong when you've got enough problems there. So, all right. And yeah, I mean, David Butcher was noting that people say that they check their guns when handed on set and that's protocol. That's what I've been hearing from everyone else as well, is that really everything should be checked. You should be absolutely saying, hey, what am I doing with this gun? Am I confident? And in fact, it's not necessarily just the actor themselves that checks it. Let's say you've got, let's say you've got a film set, and as part of this scene, the actor is going to take the gun and is going to point it at one other actor in the course of things. And then it's a Mexican standoff sort of situation. So midway through, they're going to swing the gun over to another person. And so in doing so, they're going to sweep, a wide range of the set. And maybe because of how the set is set up, there's going to have to be people there. Those people themselves can say, hey, listen, we need to be able to go, that gun is going to sweep us in the course of filming this. So not only would they set up barriers for if something went wrong, that would protect them from if there's a discharge of a blank, because a blank can be dangerous out to a surprising distance. One thing I plan to do at some point is to pick up a bunch of blanks and go to the range and do some testing and just say, how far out will this blank kill or injure you? But that'll be for a future video when I'm just trying to do things. I'm seeing there's buffering. Well, we'll have to see what's going on. Abysssoft was asking, is it common for live rounds to be on a set? No, they should never be on a set unless absolutely necessary, which again is only for like Mythbusters or that kind of thing. But all of those people who might be getting swept with the thing have can say, listen, I want to see that. I want to know that, is this going to be a safe gun? Is this going to be, is this properly, is this being done properly? So if that's not happening here, if they're not having this setup where everyone can check it before they're playing around with this, that's really concerning. This is approaching the situation where there's a principle, and I'm just trying to remember the Latin. I hate the Latin here. And, sorry, you can hear the my dog in the background here. The principle is res ipsa loquitur, and it's a civil principle, which basically says that the thing speaks for itself. And it's from a case where a barrel rolls out of a top floor window in a warehouse and crushes somebody. And so the question is, how do you establish liability? How do you establish negligence happened here? And essentially the principle is that there's no way for the barrel to roll out the window without there having been some negligence. And I think we're approaching that circumstance here. There should be no way for a live cartridge to be on set without negligence in some fashion. And particularly if that cartridge, I mean, absent something like somebody bringing on a cartridge that the armor wasn't aware of, but that in and of itself is kind of a problem. Don't they have rules against that? Don't they? It's really hard to see what's going on there. Somebody noted, check Will Smith's gun safety video. And absolutely, I will give Will Smith props here all day on this one. Because, and if you haven't seen this one, I don't have a link to it here, but there's a gun sort of scene that they're filming, and somebody goes and picks up a firearm off this table and starts handling it. And Will Smith just reaches out and grabs the thing, immediately does a check and sets it down and is like, whoa, man, because they're about to, bring it across his face. And I'm just like, solid props to Will Smith for that all day, because he is, that is exactly what I want to see. I'm seeing, Viva did a video on this. I agree with what Viva had to say on it. I mean, it's just, it's concerning to see what's going on in terms of this. All right. Unless there's any sort of further questions on Baldwin. Baldwin is kind of, somebody said it's sabotage by a bitter union walker. I don't think so. I mean, maybe. There's all sorts of things that are maybes, but there's no evidence of them at this point. So as much as you might say, hey, like, could this have happened? Sure, lots of things could have happened. But how do you get there, right? What's the actual evidence on them? And I think a lot of these sort of theories that come to the degree of like maybe they're just, I think a lot of them are more wishful thinking than. Let's try to see if I can get things going again here. Okay, are you guys able to I'm hoping I will have fixed the buffering problem. Are things looking a little better there? All right, and I may see about trying to cut the, I don't know if I can cut the latency down at this point. It doesn't look like I can adjust it on the fly in terms of the, in terms of what's going on, but I killed my VPN. That was the, I think the VPN was slowing things down. All right, so, unless there's questions here, I'm just checking to see if there's, okay, it looks like video is much better. People saying, can I donate to the new router fund? It's the VPN I was using. And I'm not hawking a VPN here. I just usually use one. So. All right. So let's move on a little bit. And I want to talk a bit about Rittenhouse. And the reason why is Rittenhouse is, I mean, that's moving along a bit. There's been a big kerfuffle in the media about them not being able to call the deceased or the injured victims. And the first thing I'll address is that. And I understand a lot of lawyers are saying, listen, I frequently get denied that in my own trials. And the thing is I'm not upset that Rittenhouse is getting that protection. I am kind of upset that other lawyers aren't. The problem with calling the deceased in the Rittenhouse trial or the injured party's victims is that it presumes fault. It presumes the legal. I mean, ultimately, what we're often determining in a self-defense case is, are they victims or are they not? So that is fundamentally a big, that's the big question that's being asked. In Canada, what they'll often do is they'll often say, hey, listen, this, we're not going to call them victims. We'll say the complainant, which technically means the person who actually called it in. So sometimes the complainant and the injured party are not necessarily the same person. And in fact, sometimes the injured party might be on the side of the accused. You see this sometimes in domestic violence situations where some third party might have called in and said, hey, this guy's beating on his wife. And his wife says, actually, he's not at fault. I started it. I was hitting him first. That can be what's happening, at trial. But victim is inherently kind of prejudicial language. It's inherently language that suggests to the jury how they should rule. Now, people have said, hey, wait a minute, why is the defense allowed to call them looters or rioters if we're trying to avoid, you know, if we're trying to avoid this prejudicial language? And what the judge actually ruled was that they could call them looters or rioters if it was actually established through the evidence at trial that that's what they were up to, in the circumstance. Then they could use that language in their closing argument. And if they can't establish that, then they wouldn't be allowed to use that. So that's kind of our basic principle here, is they have to actually, prove that in terms of before they can use that in their closing. Now, I'm just trying to sort of pull up something here because there's a few other things that I want to talk about here. Some people have said, hey, listen, he shouldn't have been there in the first place. And I don't disagree. What we're talking about there is the rules of stupid. And the rules of stupid, and I've, commented on this before. I'm not sure how this, how this has been dealt with on some other things, but basically they say don't, and I'm trying to find the proper sort of elicitation of it here. Just trying to track it down here. So, rules of stupid. Don't do stupid things with stupid people at stupid times in, stupid ways and stupid places, I guess would be sort of elaborations on all of this. What this means is essentially in terms of self-defense, most of the time when you see self-defense situations, somebody has done something dumb. Somebody has done something that that they shouldn't have been doing. So I covered a case previously where it was a self-defense situation, but you were talking about somebody who's driving around with an illegal gun and, engaged in what appears to be criminal activity. And, they're not somebody who is cloaked in honor. They're not somebody who is going to be making the news as the hero. You'll often see, for instance, people in bar fights who might have been being a giant jerk at the bar. And then later somebody waits for them outside of the bar and, tries to ambush them. And, that person is then trying to defend themselves, but we're in a situation where, where that guy's conduct ahead of time may not have been laudable. And in fact, might have been really, really obnoxious. It might be that they were saying things that no person should say to another person. It might be that they were threatening people. It might be that they were actually physically engaging in violence. They might have started a fight first a half hour prior and won that fight. And then the guy who lost the initial fight waits outside in order to basically initiate round two in a situation where he figures that he's going to win. So when we're talking about the rules of stupid here, Rittenhouse, and, I'm not saying this to really, I'm not trying to bash the guy, but I'm also not, let's look at it realistically. If you're intentionally going to a riot, that's not a great idea. I mean, there's circumstances where you might find yourself in a riot and, you might, for instance, be leaving work and you get caught up in one, or you might be law enforcement and you have to go to one. But, going there intentionally is inherently a risky activity. It's inherently something where, it involves some potential hazard. And clearly he knew that because he was armed when he went there. He wasn't planning on going there to shoot as at the shooting range or anything like that. It seems apparent that he armed himself. Now, whether or not he, we can get into questions of right to be armed or so forth, but that doesn't appear to be what was going on in this situation. It was a awareness of danger. So when you're intentionally putting yourself into a dangerous circumstance, the question is, does that then prevent you from having a self-defense argument later on? And in Canada, the answer has typically been no. Quite emphatically no. Lots of self-defense cases involve people who have put themselves in that sort of, in that kind of dangerous situation. And if and I'm not an expert on the local law, but when I was looking at it, they basically say, it seems to say, and again, I'm speaking in very large generalities here because I'm not an expert on that law, but it basically says, hey, if you start a fight or instigate a fight, you can't rely on self-defense unless you were trying to escape it or you'd clearly discontinued it or the like. Now, we can say that Rittenhouse made all sorts of mistakes in terms of getting to be where he is. And, people may disagree with me on this and so forth, but, I personally would not have gone there. That's my take on that. However, that is a different and the other thing is that much like the Alec Baldwin situation, you've got lots of people here saying, hey, I think Rittenhouse should be convicted because I don't like him. And I'm not saying that's me. I'm saying there's lots of people out there. I've had this argument with lawyers who say, listen, Rittenhouse should be convicted because he's a bad guy. He went there in order to engage in violence, and he's a bad dude, and he should be going to jail. But again, we can't use our notion, we can't use whether we like the guy, or even whether he was a good person, or even whether he was involved in good activities, normally as a reason for saying, hey, this guy shouldn't have a self-defense right. This, I will note, in terms of the circumstances, when I look at this, when I look at the actual breakdown of what happened, regardless of why Rittenhouse was there and what he was doing, what I see at the key moment is this kid running away. And I say kid because he's young, right? He's not, he's not somebody with a great deal of life wisdom. And this kid is running away, physically running away. He's not trying to engage at this point. He looks like he's trying to escape. Now, I haven't seen video that shows the actual initial first shooting. So really that's going to come down to who saw what happened, But it seems to me if you've got this guy who's trying to run away and then he can't run away anymore, he may be in a situation where he needs to defend himself. Or if he's trying to run away and he gets caught, then he may be in a situation where he needs to defend himself. I think it's going, and, this is my prediction. I think he's likely to be acquitted. And I say likely because there is no guarantees. Juries do weird things. And, sometimes the evidence might be different than what I anticipate. But I think he's likely to be acquitted under the circumstances because it appears he was trying to escape the violence at this point, and I think he's going to have a good argument for having to use the violence in protection of, of himself at that point. I think he's going to have a very I think that's a really good case. And then what happens after that is you see him attempting, and this we have better video of, you see him attempting to reach the police, which again is not typically behavior that you see of guilty people. In fact, normally you might say if somebody's trying to avoid the police, you would take that as an awareness of guilt. So clearly that would be the opposite here in the sense of, of saying if he's going to the police, it suggests that he's really thinking of himself as somebody who's in danger and somebody who's, in trouble. He's being pursued, and he does, there are further shots. And in each of those shots, it looks like it is a situation where somebody's about to visit violence upon him, and fairly serious violence. There's another critical moment that I see in that one, and that is there's a place where, he's taken one shot and somebody else goes, whoa, and backs off. And Rittenhouse doesn't fire. he holds fire on that guy who goes, "Whoa, I'm backing off." So I see here there's a situation of, you know, of him going, "Hey, he's holding his fire there." That again suggests to me somebody who is behaving as much as he can with restraint. Um, I'm seeing Agent VX saying, "I'm not particularly troubled by the idea of Rittenhouse being acquitted. I am greatly troubled by the number of self-defense activists adamantly asserting he did nothing wrong." And I think that's a perfectly reasonable take. We can say, I don't like this guy. I don't think what he did, etc., etc., etc. But still go, in law, this maybe is, this is a situation where my read on it is that he would be acquitted, you know, not just in the not just in where he is right now, which is my guess from reading sort of the law there, but I'm not an expert. But previously, I would have said that he would have been acquitted here in Canada. Now, that may have changed with the Khill verdict, and that is a very recent decision out of the Supreme Court that was rendered October 14th, 2021. And so I haven't done a full video on this. I'm going to do a full video breakdown, on Khill, and we're going to, look at that one. But what happened in Khill is you've got a situation where there was somebody breaking into his pickup truck, and Mr. Khill went and got his shotgun and went outside to confront this person. And he was dressed here. I can sort of bring up the case so that we can see what we're talking about here. I don't know if you guys are able to read this here, but they say, he retrieved his shotgun from the bedroom closet and loaded 2 shells. Dressed only in underwear and a t-shirt, he left his house through the back door in his bare feet and quietly approached the truck. As he rounded the rear of the truck, he noticed someone bent over in the open passenger side door. He shouted to the person, who would later be identified as S, "Hey, hands up." As S turned towards the sound of K's voice, K fired, racked the action, and fired a second time, striking S twice in the chest and shoulder. After S fell to the ground, K searched him for weapons. There was no gun, only a folding knife in S's pants pocket. So, of course, he hadn't drawn it at that point. He was, which suggests a less imminent situation there. So K told the dispatcher and police that he'd shot S in self-defense, as he thought S had a gun and was going to shoot him. So initially at trial, Mr. Khill was acquitted, and then later that was by a jury. He was acquitted by a jury of his peers there, and then later the Court of Appeal flipped that and directed that there would be a new trial, and said, "Listen, there was a mistake." And the mistake is essentially that, and that goes to, and I'm going to try to bring up the key bit of the law here. Just trying to find the critical section here. Looks like I may have closed it, so give me 1 second as I just bring that up. Sorry, still a little rough at the live streaming thing. All right, just pulling up section 35. All right, so, and I see Savage Arsh is asking, how much time is it going to get a PAL nowadays? Long time. Right now, it depends on which province you're in, but I'm hearing months. So that's the big thing here. All right, so let's have a look at section 35, or section 34 rather. So a person is not guilty of an offense if they believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them or another person. So that is, you have to be defending some person. This is a defensive person section. There's another section for defensive property, which, but that's not what Mr. Khill was arguing. The next is, the act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person from that use or threat of force. So that means it has to be in self-defense itself. You can't, for instance, be seeing somebody, somebody's hit you and, now they're running away and you shoot them because you're upset that they hit you. It can't be out of revenge or, malice or anything like that. It has to be for a defensive purpose. And then the next is the act is committed is reasonable in the circumstances. Now you might say, what does it mean to be reasonable in the circumstances? Well, this is a big fuzzy thing where it's like, what does that ultimately come down to? And they say the court shall consider the relevant circumstances of the person, the parties, the other parties in the act, including but not limited to the following factors. Shall is must. The court must consider these things. So first, the nature of the force or threat. So what does it mean? What kind of threat are you facing? Because the court is going to consider it much more reasonable if you're defending yourself against somebody armed with a flamethrower than they will if they're armed with string. That makes sense, right? They're also potentially going to consider things like, is this a bigger person against a smaller person, or, is there a disability involved? What are the ages? What are the genders? All sorts of factors can play into what kind of threat you're looking at. The next is the extent to which the use of force was imminent and whether there were other means available to respond to the potential use of force. So let's say somebody says, hey, I am going to kill you in a week when I get, I've ordered a gun and when it gets here in a week, I'm going to kill you. Well, that's not imminent, and it suggests that there's other means. Like if somebody says I'm going to kill you in a week, that's plenty of time to call the cops. That's police response times. But if somebody is there with, the gun right now, police response time, if you're in a city downtown, is probably somewhere around 10 minutes. You don't have the time necessarily to respond any other way. The person's role in the incident, and that one's going to be a big, thick one. We're going to get to that one later. Whether any party to the incident used or threatened to use a weapon, that's both sides. The accused who's saying self-defense and the person they're defending against. The size, age, gender, and physical capabilities of the parties to the incident, so explicitly noted there. The nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force, and the nature of that threat or force or threat. So if you've got somebody who's beaten you up before, and now you're defending yourself against them, the court will say, hey, listen, it's a lot more reasonable for you to assume that this person's going to hit you because they did it last week. Oh. And I'm seeing Dennis is saying, do the police have to tell me if they reject a PAL application, or can they stay silent? If the police don't respond, like if if the chief firearms officer, they're often really slow, and legally speaking, they're required to send you a notice of refusal. That's set out in the Firearms Act. However, if they don't do that, and it takes long enough, eventually it could be deemed a constructive refusal. That's a complicated thing and perhaps deserving of its own video, but they can't just say, hey, listen, we're denying it, but we're not going to tell you. They'd have to actually, but the question is whether they've decided that they're not going to give it to you versus whether they're just taking forever to actually make up their mind. Those are different questions. All right, continuing on here. History of any interaction or communication between the parties, nature and proportionality of the person's response, and whether the act committed was in response to a use or threat of force that the person knew was lawful. So, for example, an example where it might be lawful use of force that you're responding to, let's say I have broken into somebody's house, and that's not my jam, but let's say I decided that that was something I was going to do. And, and now that I'm in that person's house, that person grabs a golf club and they say, get out of my house or I'm going to hit you with the golf club, which might actually be a reasonable defense of their property. And so I say, listen, this guy's threatening me with a golf club, so I shot him. The court would be a lot less likely to say that that is reasonable because given that I am the interloper, I am the person who's broken in, my response to that threat with the golf club should have been to just leave. That's how I should respond to that. And I see Neil Ives says, thank you with $10, and Ben Day, thank you with $5. Thank you both. Uh, so let's have a look here, and I sort of meant to connect Rittenhouse and Cahill here, and the key bit here is this one: the person's role in the incident. So let's sort of the big issue in this one, or in terms of Cahill, was, and I hope I'm not mangling that too badly, but what this ultimately came down to was the question of, you know, Mr. Cahill's role in the incident was to come out there with the shotgun and confront this guy. And lots of people have said he should never have done that, that this is, and there's all sorts of questions as to why he did and why, like he says, hey, this person might have been able to go, get stuff from the vehicle and then have access to my house. But, lots of people basically think that he shouldn't have gone out there to defend his property. And I think that there is the prior case law had basically said, listen, it might be reasonable to arm yourself to go and defend your property, but not to shoot somebody over it. But you can go and say, hey, listen, I am confronting you. I am now videotaping you, but I'm armed. I've called the police. Stop stealing my truck. And, then you're armed not to save your truck, but to save yourself if somebody jumps you in the process. So there had been a number of cases where that kind of action had been held to be reasonable before. And so what we end up with here is a discussion of the role of the incident, because the jury was not specifically told to consider Mr. Cahill's role in the incident and whether or not his actions in going out there to confront him might have in some way been connected to this. And I see Adam Luke is asking, will Trudeau ever pay for the firearms they ruled prohibited? I don't know. There's an entirely reasonable, it's entirely possible that they'll just let the amnesty expire and then demand that they all come in and not pay anything. So I'm hopeful that they will offer compensation, but that's essentially a fortune-telling question. So what the majority determined in Khill is to, or Cahill, or I'm not exactly sure on the nuances of the pronunciation here, but is that the jury should have been instructed as to the person's role in the incident. And they note here that and I'll just try to find the language here, it captures both a broad temporal scope and a wide spectrum of behavior, whether that behavior is wrongful, unreasonable, or praiseworthy. The person's role in the incident captures conduct such as actions, omissions, and exercises of judgment in the course of the incident from beginning to end that is relevant to whether the act underlying the charge is reasonable. In other words, that as a matter of logic and common sense, could tend to make the accused act more or less reasonable in the circumstances. So here's the problem as it comes up, is that there may be plenty of activities that the jury would be more inclined to find make you not reasonable, that are actually still lawful. And so, as examples here, let us say that you are protesting in favor of an unpopular cause. Something, and I'm not going to throw out example causes here. You can fill in your own blanks. But, let's say you are, you're the guy, well, maybe, there's a guy out here who likes to stand out at the street corners, a street preacher, and he occasionally says some really obnoxious stuff, and often does so with a loudspeaker to the great annoyance of, people who have to work in the office towers nearby. So let's say you are an unpopular person, but notwithstanding the fact that he's unpopular, he's exercising, charter rights to freedom of religion and freedom of expression. So I may not like what he's doing, but he's still doing stuff that, is lawfully protected. We run a very real risk as a result of this that the court will, or that a jury might say, well, it's less reasonable for him to be out there with the signs for what he's doing than it might be if he was protesting for some cause we consider laudable. If he's trying to save the whales from, he wants to make sure whales are not armed with nuclear weapons, whatever it is. So it's
this is the question or the concern that was raised in argument in Khill in front of the Supreme Court is, could we end up with a situation where the person's role in the incident ends up including potentially convicting somebody because we think they're a bad person or that we don't like that they were engaging in lawful activities. So to connect this back to Rittenhouse, I think that Rittenhouse would now, based on this ruling, be in a lot of trouble if he were here in Canada, if this had happened in Canada, because now we're talking about a situation where people would say, listen, I don't like that he went there as a counter protester or as a medic or as a, keeping the peace, defending this car dealership or whatever it was he was doing. I've heard various different, notions on what he was up to. But regardless, they'll say, I don't like that he was there. I don't like that he was opposed to this cause. I don't like that, that he was armed, even though he may have been lawfully armed at the time. And again, I can't say that for certain. There is some debate in terms of the law as to whether or not he was permitted to bring that firearm, but that's going to be complicated legal issues. But people might say, listen, his defending himself is no longer reasonable because we don't like him and what he was doing. And that really raises what I think is kind of a concerning question, which is, how unpopular do you have to be before, it starts being that your responsibility legally, if somebody attacks you, is just to die? And I think that's a real question here, because it may be that you get a situation where somebody's actions, notwithstanding that they are lawful or not something that you would be normally permitted to attack somebody over, are so unpopular that no jury would find them to have been acting reasonably simply because of the degree to which that activity was unpopular. That's my real concern here. There's going to be a lot of, questions here now. There's been a lot of news coverage about the fact that the deceased in the Khill case is an Indigenous person. And, Canada is not fair. There is a long history of discrimination, but that doesn't necessarily mean that we should change the self-defense rules in the, in a particular case. And so you might end up with circumstances where somebody is going to be convicted based on the ethnicities of the people involved. And that could go either way. If you're talking about some area where the jury might be more prejudiced against Indigenous people, they might say, listen, we're finding this person to be less reasonable for that reason. And we're never actually going to be able to inquire into what was going on in the minds of jurors, because that's actually specifically forbidden. My wife is actually doing jury duty right now, like not right this second. She's not, I'm filming this at 8 at night, but, she is in the middle of being a juror in a jury trial. And I don't know a damn thing about what's going on there. I know that, it's a jury trial, but she's not permitted to discuss their deliberations. And, she's erring on the side of caution by just not discussing the case at all. I don't know what's going on there. But, we're not in a situation where we can actually inquire as to whether that was going on. And I'm concerned that this is going to invite court or invite juries to essentially go into all sorts of impermissible reasoning, into all sorts of questions as to whether or not we really like this person and whether we like what they were doing. So the dissent was basically saying, listen, the dissent, or I say a dissent, it's actually kind of a concurring reason. And it's the concurring reasons of Moldaver, Brown, and Rowe. And they basically agree. It's concurring reasons because they agreed that the trial decision should have been overturned, but they disagreed exactly as to what the law should look like. And hey, thank you, Jay. I see the little emoji. Thank you. And Les asked, "You're married?" Yep, I'm married. You might be hard to believe with sort of how I keep my hair, but I am married.
So the what is it? The sort of concurring reasons here basically said yes, the jury should have been instructed as to the role in the incident thing, but they said, listen, we need more boundaries on the instruction. We need more. I see Wayne Hitchcock saying, "Don't get too excited. It's Taiwanese dollars, 300 Taiwanese dollars." I have no idea what kind of actual conversion rate that is, but nice on the big numbers there. Uh, so the concurring reasons said essentially that the jury needs to get instructions saying, listen, you have to consider all of the circumstances, but you have to consider them in the sense of uh, bounding them to things that would affect the ultimate decision and making sure to caution them to avoid irrelevant details. Irrelevant details being things like, how much do we like this guy? And so I really like the concurring reasons a lot better. And I don't just say that because Brown was my old torts teacher, but I really like a lot of what he's done on the Supreme Court. I like a lot of his positions. I think he's often in the right. So I really tend to, although not always, but often. Uh, so they say, role in the incident includes but is not limited to provocative, unlawful, and morally blameworthy conduct. When we say that it's not, that's concerning. So but the majority noted here, I'm just going to try to bring it up here. My colleague and I agree that role in the incident goes beyond provocation and unlawful aggression. However, overlaying a standard of wrongfulness or imposing a novel application of excessiveness onto the clear words role in the incident is unwarranted. So what the concurrence, the sort of dissent wanted to impose here is a notion that role in the incident really covers wrongfulness to some degree, or whether you were engaged in some sort of bad activity, and so would prevent the jury from determining that you were unreasonable based on actions that are lawful or even laudable, that are charter protected. So that's sort of the concern there. They say it imposes additional reasonableness assessment onto the role in the incident factor rather than focusing the assessment on the overall reasonableness of the accused's act. Further, while provocation had a settled meaning in the jurisprudence, the category of excessive conduct, insofar as it applies to the consideration of the accused's behavior in the sequence of events leading up to the purportedly defensive act, is a novel addition to the law of self-defense and is not grounded in either the parliamentary record or scholarship in this area. This one, that particular point, I will give to the majority because I couldn't see it anywhere it would be a sort of novel thing. However, that happens all the time. So this is kind of my concern with what's happening with self-defense here. As I said before, I think that in terms of the law, you may not like Rittenhouse. You don't have to. I don't like a lot of the people who succeed in self-defense cases, including in Canada. The one I covered previously involved somebody who was clearly involved in unlawful activity. They had an illegal handgun. But I still think that person should have been acquitted. And I think under the circumstances that Rittenhouse should be acquitted. And I know that's going to be an unpopular stance. It's not that I say that he should be acquitted because I agree with what he was doing or that, anything like that. It's just that I don't see what other option he had in the critical moment. In the critical moment where he's being rushed by a guy who has a violent record and seems, there is video of him being rushed at that point, and it doesn't look like it's for friendly purposes. It doesn't look like that guy intends to do him any kindness. So, where you've got Rittenhouse being rushed and trying to escape and apparently failing to escape, I think it's very hard to get out of the conclusion that there's got to be at least reasonable doubt on that being a defensive incident. And the arguments I hear, including from lawyers to the contrary, are all basically arguments to say Rittenhouse shouldn't be able to defend himself in that circumstance because we don't like Rittenhouse. And I don't like that argument. I do not like this notion that bad people should not be able to defend themselves in these in situations. And I think that a lot of the people making that argument are ultimately failing to consider the larger impacts. Let us take, sort of switch back to Khill for a second, and let's imagine, for instance, that situation was reversed. Let's imagine that the deceased, still doesn't have a gun, but he does, we know he had a pocket knife. Let's say he goes out and he sees this guy who is barefoot and who's half dressed and is probably looking a little wild-eyed because it's late at night and so forth. And so let's say, he sees this guy pointing a shotgun, and let's say Khill took the first shot and missed and put that right in, through the truck window. And then the other guy rushes, the deceased there, let's say he rushes him with his pocket knife and manages to beat Khill and kills him. This isn't what happened, of course. This is a pure hypothetical. That person would then be relying on a self-defense argument. And his self-defense argument would have been, listen, yes, I was doing a bad thing. I was totally, stealing either the truck or from the truck. And then this guy comes out with a shotgun and takes a shot at me. And my only recourse at that point was to stab him. At that point, it's a situation where, he would be relying on this same self-defense argument. And so all of the people here who are essentially saying we don't want to see Khill acquitted because we don't like Khill or we don't like the optics of the situation should consider that it could easily have been the other way around. And had it been the other way around, we end up in a situation where it might be very difficult for for that accused, if that were the situation, to be acquitted under the rules that people are suggesting. So one thing that is really concerning to me that I'm seeing a lot of in society is we see unpopular cases, and, they happen all the time. And, we've got the Gomeshi trial. We've got, oh man, I'm terrible with names, and you'll have to forgive me on the fly here. The Stanley trial, there we go. Where we've got very unpopular accused and unpopular verdicts. And people say, listen, we got to change the law. We got to really, rework things in a big way. That scares the hell out of me, because every time we change the law to prevent some, really unhappy circumstance, that we end up making things a lot worse in terms of how the law works. It always is a ratchet that makes things more towards incarceration, less towards freedom, less towards personal responsibility and personal decision making, and more towards sort of state control. So yeah, Rittenhouse here it's not a Canadian case, but it does provide a little bit of a parable in terms of how Khill ends up being approached. And lots of people will say that this is a feature, not a bug. If Rittenhouse getting convicted is, a good thing. But, Rittenhouse, even if he were there and were not, armed with the rifle, the same principles would apply. He would have just been less able to defend himself. This is all kind of frustrating. I think that there is a real tendency to want the law to give us good outcomes instead of being built on good principles. And I'm the other way around. I want to see law that's built on good principles that will generally get us to good outcomes. But if it's only built on we need to get whatever outcomes, then we end up with a law that we don't understand what it is. We don't understand what it means. It's too fuzzy. And essentially, it opens the door to lots of prejudices and biases being the basis on which people are convicted or acquitted. And I don't want to see that. I like my reasoning, and the reasoning I like in court decisions tends to be ones that say, what are good legal principles? And then once we have the good legal principles, where does that take us? What, once we apply those principles, what does that, what result does that take us to? And that result might be unpopular. Lots of people will tell me, hey, listen, I want, people say, listen, I want to see elected judges, or I want to see judicial accountability because I don't like this result. And I always say that is a bad move because, we're supposed to have judges who apply the legal principles to good, to to whatever ends that they take us, even if they're unpopular. I don't want to see a situation where judges are acquitting or convicting somebody based on whether or not they think it's going to be the popular decision or the decision that gets them reelected. That, that possibility scares the heck out of me. And it should scare the heck out of you too if you're a gun owner, because I will tell you, a lot of gun owners are not necessarily popular. And do you really want it to be a situation where the court says, hey, where you get, judges running on pro-gun control platforms or anti-gun control platforms, whichever side of the issue you're on? No, I want judges who apply the law. Anyway, that's kind of it. I suspect probably what I will have said here is a whole lot of unpopular stuff to lots of people, but I'm not really running this stream to be popular, and I'm, as much as I sort of look at the subscriber count, I don't really worry about whether or not, a video is going to take that up or down, because at the end of the day, the law is the law. And I want to just sort of share that with you as much as I can. I do love the law. I do have it's kind of a beautiful thing. And I see Abyssoft was asking, do you think this view conflicts with the living tree doctrine? I'd say not really, because the living tree doctrine, if you're not familiar with this, is a principle of constitutional interpretation. It's sort of a rejection of originalism. But I think that the law can evolve, and you can see situations where you can have where, for instance, a rule might not make sense anymore. One thing that's come up quite a bit is technology has made certain principles maybe not apply as much. And we may start to see some of the, the rules of evidence start to get shifted in some ways because they maybe just don't apply the same way. That's, the living tree is part of that. It recognizes that society can evolve. The meaning of what certain rights can take on can evolve. To me, when you see like originalism, like freedom of the press, some people make this argument in terms of firearms. They say, oh, well, there was never any right to, have semi-automatic firearms because they were using, muzzle loaders. And I go, well, we understand that the right evolves, right? They never envisioned the photocopier when they were talking about freedom of the press or freedom of expression. They certainly didn't envision anything like Facebook or Twitter. Even back when the Charter of Rights was invented, was drafted, the notion that right now I would be able to go on Twitter, find a random actor across the country, send them a message, and then get them to angrily reply and send 100,000 of their followers to hassle me would have been like an unfathomable circumstance. You just couldn't have imagined it. So the living tree doctrine sort of means that rights can evolve and we can look at the purposes. Freedom of expression doesn't die just because we're not using the printing press. It has to grow into these new technologies. But again, you have to take reasonable interpretive steps. You have to say, this new technology, what principles apply? How do we adapt the law here? How do we adapt how we deal with this? So I guess that's my sort of take on that. I'm kind of playing law professor here, but yeah. So yeah, I guess I'll sort of open things up to questions. I've sort of said what I, came on to say. I don't know if it was clear at all. I don't really know, I'm new to this whole live stream thing. I do not, this is the first one I've ever done. I have figured out that, I got to turn the VPN off. That's a big thing there. But I take it. I saw that people were saying that the video and audio quality is much better afterwards. Is that a fair assessment? I see somebody saying that they got a ride in an RCMP cruiser and had an AR-15. Canadian Pressure says, keep doing your thing, Ian. We're grateful for you and your insight. Well, thank you. And I mean, ultimately, all of this is just, the law is fun, but the law is also, it's such a chaotic and difficult thing. And one of the things I find frustrating, and I'm not, when I say this, I'm not saying this to sort of dunk on gun owners in any respect, but when I first started sort of looking at the legal community, what I saw was a lot of legal myths being shared, and a lot of sort of things that people had passed along as wisdom about the law that was not correct. And so I really thought I should say, hey, listen, let's try to put more information out there, especially because I really hate seeing, I do criminal defense. My livelihood kind of depends on people getting arrested and charged and so forth. But I always hate when I see people who are arrested and charged for things that they reasonably believed were, innocent. Things where people have made a mistake of law or where people have made some sort of minor screw up. I hate seeing that. And I would love to see, I'd love to entirely eliminate that area of practice, which is basically a lot of what I do, but I'd love to eliminate, that sort of thing. Somebody was asking if they're going to see more gaming streams. Well, I've got Extra Life coming up. Going to be doing that on November 6th. Trying to arrange it. Right now, I'm sort of scheduled to do 12 hours. I'm trying to take that up to the full 24. But I'm going to occasionally be on Twitch doing whatever. I don't really understand the whole Twitch thing, but it's fun sometimes to do, so I'll be doing that. I see Salty Coins saying, bro, me and my buddies watch you all the time. Thanks for your insight. Sending lots of love, my man. Thank you. I can also say, just as kind of a weird aside, I really didn't ever expect to be doing YouTube things. I kind of thought, that this was, I sort of started this because I had some people saying, hey, you got to make videos. I still don't know how to deal with that. I'll tell an entertaining story on this one. Because I am really not used to sort of being somebody that people recognize. But I was at the range the one day, and I'm there and, just shooting down range, everything's good. And this guy comes up to me and he starts yelling, hey, hey, and he's waving his arms and he's running towards me. And I have a little moment of panic, right? My heart just drops. And so I immediately, pull out the mag, empty the chamber, make the gun safe, set it down, step away. Because when this guy's coming up and, waving his arms going, hey, hey, I'm thinking there's somebody downrange, maybe like somebody who was behind the berm and I didn't see them. And for some reason they didn't set the, the range lights properly. I'm wondering, is there some safety issue here? Anyway, he runs up to me and he's like, hey, I love your channel. I went, okay, there's a way to do that doesn't give me a heart attack, please. So yeah. Somebody was asking, would you consider doing another spot Viva with Viva and Barnes? I enjoyed the heck out of it. I have tremendous respect for those guys. So yeah, absolutely. Somebody asked as a personal question, with your hair, are you still required to wear the wig in court? In Canada, we don't do the wig. In Queen's Bench, you have to do the robes, and the robes are the most expensive outfit I have. They cost me about $2,000, which is ridiculous. Well, they didn't cost me. They were actually a gift from my articling supervisor. So, I shouldn't say they cost me, but they cost $2,000, and you can't wear them anywhere else. They're useless. So I'd rather just do a suit. Somebody asked, what do you think about buying legal insurance as a regular citizen? It's really hard to say. Check your you got to check your policies. You got to check who they cover, if they cover the people you want to deal with. And I don't know enough about the legal insurance, so I can't say for certain. But yeah, somebody asked, did you go to U of A or U of C for law school? I was at U of A, and I quite enjoyed it. I don't know anything about U of C, so I'm not going to talk smack. I'm not a sports guy, so I'm not going to get into the sports rivalries. Somebody said, hey, have you ever done an NCR case? I have not, actually. I thought I might do one, but it didn't end up happening. So NCR is not, is complicated. There's not a whole lot of NCR cases that happen. So hasn't come up. Somebody says, what defines a gunsmith in Canada? I can't find a clear explanation in the Firearms Act. Basically, if you've got a firearm business license that allows you to do gunsmithing, that's the whole of it. There's not anything else to it. You can smith your own stuff on your own, but if you're engaging in business, you typically need a business license. Just somebody saying is, can firearms here be exported to a family member in the U.S.? The big thing is going to be U.S. import requirements. Canada does not put a whole lot of limits on exporting firearms. It's actually, Canada's export and import laws are really kind of lax. You can export and import things fairly reasonably. I've got not a whole, but the US has really complicated rules. So the sticking point isn't going to be the Canadian law on that point. It's going to be the US side on that one. And I see somebody saying, in the military, taught to clear a firearm before handing it in and receiving it. Still do that today before handling any firearms. That clearly did not happen. I mean, you're not wrong. With the Baldwin situation there, when I take newbies to the range, I let them see me do that every time I pick up a firearm, and I show them that I'm doing that. So somebody who comes in, they don't have a license, I pick up the gun, I show them that it's clear. I think the last time I went, I, showed them that it was clear, walked over to the range table, and then showed them that the same gun was clear again. It obviously wasn't going to get loaded between me walking there and me getting to the range table, but I still, take the time to actually do that. I see Paul was saying, hi, I'm Paul from the US. Really enjoy your channel. I'm kind of surprised because I do almost exclusively Canadian law, but glad to have you here. Somebody's saying, any tips for an aspiring law student? You know what? I will probably do a video just on what I suggest for aspiring law students. If you've got a 3.9 GPA and 169 LSAT, I think you're going to get in. In terms of getting into tax law, just take the tax courses, and I can guarantee you there are firms that are looking for tax lawyers, because lots of people don't want to do tax. I will say that as much as I think tax sounds like the most boring area of laws, the people who I've known who've gone into tax all actually seem to be fairly fun people. So I don't know how to reconcile that one. That's a weird one. Somebody was noting that they've exported firearms and there are businesses that do it for you. Absolutely. And people, when they ask me how to, they say, how do I get this gun in from the States? I always say, go to one of those companies. That's the easiest way to do it. And it makes more sense than, makes more sense than hiring a lawyer to do it. Because as much as those companies might be expensive, it's still way cheaper than lawyers' times. Somebody saying, could the Baldwin thing have been the result of a blank being fired while an obstruction was lodged in the barrel? It could have been. I don't know that is the case, but it doesn't seem to be here. The other thing is that that's something that they're supposed to check. They're supposed to actually use a rod or a flashlight so that you can tell that there's no obstructions. And again, that's because of Brandon Lee. Somebody died because there was a barrel obstruction. And so the safety practices updated to make sure you check for that. If that happened, that still indicates that somebody didn't check to, what was going on. Somebody says, can you take the weapons you own here in Canada to the country you're moving to? really is going to depend on which country you're going to. Canada does not tend to prevent you from exporting things, but lots of other countries, want to see things. Uh, any chance that the new list of prohibited firearms will get overturned? I'm hopeful. There's a court case on the go. It's got a lot of really, excellent people on it, and fingers crossed. I I try not to predict the future. But I really hope it'd be really nice to take my AR to the range again. So yeah. How do I feel about first past the post? Well, that's a tough one. Um, I mean, first past the post tends to cause distortions in the electorate, in the sense that, you can get people elected not because they're the most popular, but because they're sort of because they're able to position themselves as vote for us or somebody else wins. I think the Liberal Party has long managed to ride that particular horse, where they say, hey, I think there's a lot of people who might vote NDP if the Liberal Party wasn't sort of the designated alternative. And, so it's problematic. But the question is, what do you replace it with? And that's where you get even more trouble, because the Liberals clearly, when they were saying, hey, we want to eliminate first past the post, the system they wanted was one to replace it with something that would have guaranteed them things. Which Canadian Firearms Association would you recommend? All of them. I think I've got to renew one of them, but I maintain a membership in all of them. I think it's good to have different voices. I think it's good to have different perspectives. That's so whatever one you agree with, or all of them if you've got the cash. Would you ever collab with Ian from Forgotten Weapons if you got the chance? Absolutely. So I think that is a long shot in terms of chances. I would have to. I don't have any way to get his attention. That's really the big thing. He's a huge name. He's got massive followers. I have said on many occasions that my channel is the second best firearm channel run by a guy named Ian. But if he ever has questions about, Canadian law or wants to do a video on that, I'd be happy to, but I don't think it's likely to happen, just because I don't, as much as I'd love to, it's hard to get his time, and he doesn't owe me anything. So if I say, hey, I want to do a collaboration, it's like, cool. That's exactly it. He doesn't owe me anything, and, so if it's useful to him, absolutely. If not, it probably won't happen. Somebody says, what is your favorite cheese? That's kind of a tough one. I'm trying to remember the name of it. It came from Granville Island Cheese Shop. Oh, I like a Saint Agur. I like a bunch of things. I kind of also like some blue cheeses that some other people are not fans of. Somebody asked, what is my daily carry knife? Really depends on the circumstance. I kind of like this little thing. It's just a fixed blade, so I don't have to worry anything about, folding knife rules or anything like that. But just a little tiny thing. It's a really practical, right now you can see a smudge on it from, of all things, cheese. So whoever asked me which one I liked, which cheese I liked, was actually a good question there. But this is an Ed Storch knife. So if you know Ed out here, he's kind of a face who's at the gun shows. This is not paid promotion in any way. It's just, he does good work. I saw his knives at, I've seen his knives on lots of occasions, and finally I bit the bullet and bought one, and I quite like it. It's just a little skeletonized thing. It's really light. It's really small. It's great. So I'm just looking here. I see somebody eats a whole package of Baby Bell at once. I'm not the hugest fan of Baby Bells. Think about vids on general legal concepts. I do some of them. Jay had said, you're full of knowledge, and knowledge is power. So thank you, Jay. Somebody asked thoughts on concealed carry. Well, that's kind of a thorny issue. I think that there should be more of it than there is, but maybe less of it than some people might like. I would probably, given, sort of ultimate authority, look at setting up a separate level of carry permit, such that, after you get your PAL, you go and then further apply for a carry permit. And that's just because, you know, I think that maybe some additional training would probably be helpful there, just in terms of things like the PAL course covers absolutely nothing on use of firearms. It covers safety, but it covers nothing in terms of things like, how to draw, how to conceal properly. Covers nothing on things like, legal tests. There is nothing in the PAL course about when you can and can't shoot somebody, because they would say never. And the law actually says that that's not quite exactly the case. There are circumstances where you might be justified in doing so, but you'd need an additional course on those principles. Somebody asked favorite gun. Oh, that's a tough one. I really do like my Chiappa Rhino, and partially because it's fun to shoot, but also partially because it's engraved with paid for by the chief firearms officer, which is, sometimes it's worth doing a victory lap on certain things. I also like my SIG P226. I used to really like my AR-15, but it's less awesome as safe decoration. I like lots of things. I like my I like my double-barreled shotgun. I like my semi-auto shotgun. I like going out and breaking clays at times. Somebody's asking, do I read many books and what kinds? Well, I have a lot of books, but it's hard to find time. I used to read a lot of science fiction. These days, I tend to read a lot of law. It eats up most of your time, and by the time you've spent 6 hours reading through legal briefs and so forth, going, hey, I'm going to do some reading for pleasure, often doesn't feel like what you want to get done. So that, that's one of the downsides about law, is that you will possibly feel like maybe you've lost reading as a hobby, and I should try to get back into that. All right, I see somebody saying SKS is for everyone. I like my SKS, but it's not super accurate. Cam says, "Are you a natural blonde?" Back when my hair had more color, it was brown, but it hasn't been brown for some time. Somebody says some states make it mandatory to take a CCW course before you get licensed. That might make sense too, but honestly, I mean, I would set it up. I would kind of say, hey, if you're setting it up in a situation where that's a license, that really, there's plenty of people who aren't going to be interested in that. You're going to have people, I don't know that they need to take a concealed carry course if all they want to do is go hunting or break clays. I'm fine with a license that sort of breaks things down into what you're doing. I mean, if we're having a licensing scheme, and that's its own other question. But yeah, some countries make that hair requirement for all lawyers. Well, actually, they make it a wig in those countries. I think in those countries, you actually have to, even if you had hair like this, you'd have to put the wig on. Does the carpet match the drapes? That one I'll just give a pass to. This is, what is your go-to rifle? Your rifle you bring into the bush for plinking, hunting, whatever. I mean, it depends on what I'm doing. I have taken out the 1022 is a great sort of pack into the bush rifle for plinking and, for small game, for, grouse or whatever. I want to get a 22 and like 410 or 20 gauge over and under. I don't have one. My dad's got one that he's said I will inherit at some point, so I haven't gotten to buy one, but one of these days I want to buy one just as a grouse gun. I would probably, if I were designing a gun, I might design like a skeletal break action, because I've seen like the small shotguns and I've seen the small break action 22s, I don't know if there's like a skeletal hiking bush 22 410 over and under. Because if that exists, I could totally see picking one up, or 22 20 gauge over and under. But I mean, for other things, there's lots of different things that I use for different purposes. But people always ask, like non-gun people say, why do you, why would you own more than one gun? And it's like, well, because it really depends on what I'm doing with it. If I'm out there shooting paper, I might want to use my 22 handgun. I might want to use a 22 bolt action. I've got a different 22 that I take for training newbies. So yeah. Somebody says, still waiting for the guitar solo. I am not a guitarist. Somebody says, when are you having Viva Frey on your live stream? Anytime he wants. I suspect, he's a much bigger name. I am happy to go on his live stream anytime he wants. So that is, somebody said, I think Baikal at a 22 410. There's lots of 22 410s out there. I'm just thinking of one that's like the skeletal hiking version, one that's made as a really light, a takedown or a folding one. What are your thoughts on the survey the Liberals did concerning a ban on hunting rifles and shotguns? I'm not super surprised. You got to sort of recognize that the end game for some of these types is to see every gun in Canada banned. But yeah. Active self-protection showed a guy in Toronto using dog spray in a self-defense scenario, and the police didn't charge him. What do you think about carrying dog spray where dogs could plausibly be present? If you're carrying dog spray for the purposes of using it on people, they will charge you with possession of weapon for purposes dangerous to the public peace, possibly carrying a concealed weapon. But you can carry dog spray for the purpose of protecting yourself from dogs, because of course, dogs are a potential threat. So, that's sort of an important distinction there. If you are carrying dog spray for the purpose of protecting yourself from dogs, the police will try to talk you into agreeing with the notion that you are going to protect yourself from people with them, or, the like. But, yeah, you don't want to, you don't ever want to talk to the police about why you're carrying anything. I carry this little tiny, this thing is not what I would consider a great defensive weapon. It's really tiny, but this is not carried for self-defense. But I'm sure that if I ran into a police officer, they'd be saying, hey, you'd agree that that's, for self-defense. And I'd be like, nope, I don't have anything to say. We're not having this conversation. So it's tough. You can't do anything unlawful there. Adam Jensen has blades built into his arm. Assuming they aren't legal, they'd be all right under replica knife laws. Actually, they'd be illegal under all sorts of things. Maybe I should do a video on Adam Jensen's arm knives, because that might be a fun one, just in terms of talking about how many laws that violates. Clarification on forced jab and charter rights. So far, I haven't seen any proposals on forced in terms of like somebody's going to come up and stab you with it, which would raise some pretty serious charter rights. A lot of what I see raises employment law questions, and I'm not an employment lawyer. So, yeah. Somebody's saying, do you reload? I would like to. I need to get in touch with my insurance company to make sure that my insurance company is okay with it. Every time I ask them, they say that there's apparently a policy on reloading, but there's no indication. They keep saying we'll get back to you as to what it is. So I want to make sure that if I reload and if I have if I have powder in my house, is this going to invalidate my fire insurance? Because of course having fire insurance is also a requirement on my mortgage. But I'd like to reload because some of the stuff I shoot is expensive. I've got a 6.5 by 284 Lapua. I can tell you that's not cheap to feed. I would love to get in. I do actually have reloading dies for it, but I need to learn how to do that and all of that stuff. All right, so we've been at this for about an hour and a half. I think I'll probably wrap it up here. Um, this has been a lot of fun. It's been a lot of fun being able to engage with you guys and talk. Um, I don't know when the next live stream will be, just because it's going to be sort of a thing there. Somebody says, are brass knuckles that are made of plastic a prohibited weapon? No, I've got a video on that, which you should check out. Can I do a video on what is required or not required during a police interaction? Yes, although that gets complicated by provinces, but that's a good one. Bianca Carson noting brass knuckles have to be metal. Yep, absolutely. And so, yeah, I'll sort of wrap it up here. I'm not sure when the next live stream will be, but there will definitely be live on Twitch on November 6th. And that one is a fundraiser for Extra Life. That one goes to the Stollery Children's Hospital, so Children's Miracle Network Hospitals. Let me just pull up a link here if you want to donate to that here. I'm just going to take a second here. Just pulling up my page just so I can drop that into the chat. I initially set my initial goal had been $500. That turned out to be too modest because I accomplished that a little quickly there. I'm hoping to. I've set my goal a little higher now. Mostly just however much we can raise for kids is fantastic. Lots of people out there who are going through some rough stuff. I mean, I spent a lot of my early years in hospital. I used to have really bad asthma, so my earliest memory is actually of being in an oxygen tent, which is not a whole lot of fun. So the kids who are off in the kids who are off in those hospitals, anything we can do to make them a little more comfortable or increase their chances is something I'm in favor of. Because yeah, so I see Chris Whitehands. Thank you very much, sir. Awesome show. Thank you. Are we actually able to ask the RCMP why they need 30-round magazines, etc.? Well, they're going to say that they need 30-round magazines in order to, to deal with, well, shooting people is why they want them. But, I mean, yeah, I suspect that the situations in which the RCMP both fire their AR-15s are very low, and the situations in which they empty their magazines are even lower. But that's policy. That's lawsuits over previous situations. That's all sorts of things. And talk sometime about the RCMP reclassifying antique revolvers. That I could definitely do a video on at some point. And yeah. Anyway, I will let you guys go here. I'm going to probably have something to drink because my throat is getting a little dry here. And probably not, well, who knows? Maybe of the Scotch variety here. Anyway, thank you for watching. Again, I left a link to the Extra Life there. Thank you to Dances with Empties. And somebody was asking if my name on is the same on Twitch. It's Runkle of the Bailey, all one word on Twitch. So if you want to find me, that's where I am. Anyway, thank you once again for watching. It's been a lot of fun and a great first effort into live streaming. And I hope I've armed you with knowledge. Have a good night, folks.